Final speaker of the night and our final speaker of the series was, prior to his appointment in 1975, one of the leaders of the Bar of Northern Ontario and a partner in the firm of Weiler Maloney from Thunder Bay, indeed a firm that has spread its Weilers and Maloneys throughout the province and throughout the practice of law in Canada.
With that rather neutral introduction, Brian, harking back to what you said about your introduction earlier in this series of His Honor Judge Grayburn and the introduction tonight of Judge Wheely, I hasten to state that I was never a Crown attorney, was never president of the Criminal Lawyers Association. I thought you'd at least introduce me as a likely impartial judge. I'm very well aware of the fact that this is late in the day, that this is the 15th lecture over a period of 5 weeks. You must be bored with the sheer volume of it all. With that thought in mind, my good friend, young Tom Carey, a budding young criminal barrister out in Brampton, suggested that since you were going to get a transcript of my text, my paper anyway, that I ought to simply use my allotted time by telling a few jokes. No, I really was seriously considering doing that until I was made aware of the fact that this whole thing is being recorded on videotape. And Brian tells me that last year's series, the tape of last year's series, were taken by he and others to such places as Thunder Bay and shown to the local bar. And I've long since, I hope, lived down my reputation as the resident buffoon from Thunder Bay. Besides all that, bearing in mind the nature of the audience that I was likely to be addressing tonight, and looking at my fund of stories, knowing how sensitive you people might be, I couldn't come up with any stories that were not too indelicate for your ears. So you're going to have to bear with me as I read through this paper. I've been asked to speak about the subject of recent developments in the law of extraordinary remedies. In preparation for this speech, Brian Greenspan sent me a copy of a speech recently given by his brother Eddie on the same subject. That speech was given in the Law Society's special lecture series, and no doubt is due to appear in print fairly shortly, as this one will. Now, I couldn't really find much fault with the research that had gone into that speech. I guess that's one of the problems when you're dealing with lawyers like Eddie Greenspan, who have lots of spare time to put in as editors of the law reports and of the criminal code. So I was left with two choices. Either I could plagiarize and read Eddie's speech in the hope that none of you people had attended that lecture, and then when it later came out in print, you'd assume that it was more likely that Eddie had stolen the speech from me than vice versa. Or I could, in the alternative, get one up on Eddie by concentrating on even more recent developments than he did. And so in the great tradition of judicial innovation, I've chosen the latter route, and I'm afraid that you people will have to spend some more money to buy the Law Society's special lecture publications, as well as the materials that I understand will be published as a result of tonight's proceeding. But I do want to start with an excerpt from Eddie's speech about the importance of appeals rather than extraordinary remedies. Near the beginning of his speech, Mr. Greenspan put forth his main contention, I quote, "The critical feature in understanding remedies in criminal law is the fact of the appeal remedy. Since the enactment of the Criminal Code in 1892, and certainly since the extensive revisions of 1955, the fact of appeal has not only shaped the law of criminal remedies, but one might suggest it has distorted that law. It is impossible to review the provisions of the Code, the decisions of the appellate courts and the Supreme Court of Canada, without concluding that the right of appeal afforded an accused is meant to be the exclusive remedy in the criminal justice system. Eddie goes on to say that that's not necessarily bad. There's considerable merit to the single route of review, and in the majority of criminal cases, the appeal system is not only the remedy required, but is the only remedy required. However, the problem I perceive is that in this headlong rush to appeal, important rights of citizens are becoming trampled. While I concede there is a certain orderliness and efficiency in placing the remedy at the conclusion of the process following the conviction, this tends to ignore the fact that some important rights are determined along the way to conviction or to acquittal, rights which deserve protection and for which the appeal remedy is neither appropriate nor adequate. I end the quote from Eddie's article. I certainly do not want to take issue with the notion that appeals are meant to be the most important check in the system of the administration of criminal law. However, I want to direct my lecture tonight to counter an inference which seems to arise out of the emphasis placed on appeals. That is the inference that extraordinary remedies have had their power eroded to such an extent that they have been effectively stripped of their force. Reviewing the recent law in this area, there were 4 decisions which stood out in my mind as good examples of the varied use which is still being made of extraordinary remedies and the crucial power which they still hold. The first case is Re Keenan and the Queen, decided in this year by the Quebec Court of Appeal. Incidentally, I'm not going to give any citations as I go along, and because they will appear in the printed material, and indeed in the interest of saving time, I'm going to try and shorten some of the quotations which will appear therein. Getting back to the Keenan case, in October of 1977, the Montreal police burst into a bar in the west end of Montreal and arrested more than 60 people and charged them with being found without lawful excuse in a common body house. That large number of arrests led Justice Montgomery of the Quebec Court of Appeal to observe, and I quote, that if the premises were indeed a body house, it was an uncommonly commodious one. That also prompts me to observe that the extent of the law of judicial notice is an interesting topic. It now seems that in Montreal, at least, judicial notice stretches to knowledge of the spaciousness of body houses. On the day of his arrest, Keenan was taken before a municipal court judge, was charged, entered a plea of not guilty, and was notified that he could be released on condition that he enter into an undertaking. It is the content of that undertaking which gave rise to the legal proceedings before the Quebec Court of Appeal. Keenan undertook in part as follows, and I quote, to report to a doctor at a specified detention center between specified hours on a certain day and on other dates determined by the said doctor. The next condition, to undergo any appropriate medical treatment which the said doctor might suggest. Now, Keenan subsequently applied by way of certiorari to quash the release order on the basis that the judge had no jurisdiction to impose the condition relating to undergoing any medical treatment which the doctor might suggest. The application was dismissed and he again appealed. On that appeal, counsel for the Crown argued that Section 710 of the Criminal Code prevented the court from even considering the remedy of certiorari. Section 710, of course, is that privative clause which denies certiorari in cases where an appeal has been taken by an accused or where the accused appeared, pleaded, and the merits were tried, and an appeal might have been taken but was not in fact. The Crown was as it were, asserting Eddie Greenspan's contention. That is, the Code emphasizes appeals as its main remedy and has edged out extraordinary remedies. In this case, the Crown pointed to the fact that the Code contains extensive provisions for bail reviews and the accused had not followed the review route. The court rejected the Crown's position and allowed the application for certiorari. Mr. Justice Lemaire, speaking for the majority, said, I quote, there remains, therefore, 2 questions to be considered. One, is the review provided for in Section 457.5 an appeal in the sense which this word is used in Section 710? And 2, can it be said that the appellant appeared and pleaded and that the case was decided on its merits. I continue with the quotation. Proceeding to apply these principles to the first of the two questions, I cannot by extension conclude that the review in section 457.5 is an appeal within the meaning of section 710. That section, section 710, the quotation goes on, is a privative position respecting one of the oldest remedies in the British legal system by which the king's subjects could seek protection from the king and his courts when confronted with an excess of local powers. It is principally the prerogative writs, certiorari, prohibition, mandamus, habeas corpus, that our judges become, by means of these writs, judicial ombudsmen. Only by the clearest words in a statute would I consider myself able to refuse the citizen his right to this remedy. These remarks apply just as much to the second question. By extension, one might even transpose the terms of paragraph B of section 710, which really apply to a trial, to make them govern an application for and a decision on bail. This asks, however, for the kind of extension which the rules of interpretation with respect to privative provisions do not permit. End of quote. In what was really a very interesting decision, Mr. Justice Lemaire decided that bail conditions had to have a causal link with the crime with which the accused is charged, and that requirement had not been met in this case. Accordingly, the judge below had exceeded his jurisdiction, and certiorari was granted. Without deciding exactly what a bail review entailed, that is the old question as to whether it's a trial de novo, an appeal, or some sort of a hybrid creature, the court restricted the meaning of section 710 as closely as was possible. And so the Keenan decision shows a court squarely taking issue with the contention that the criminal law must reduce the scope of extraordinary remedies in favor of an expansion of the appeal route. The reliance on appeals is to be restricted to the clearest cases where the code sets out statutory requirements for an appeal. If there's any doubt, the doubt is to be resolved in favor of leaving unhindered the traditional jurisdiction of superior courts to order extraordinary remedies. Now, my second case, the second of the four cases to which I propose to refer, is the Queen versus Stillo, or Stilo, S-T-I-L-L-O, a decision of the Ontario Court of Appeal, which was just released on June 24th of this year. Mr. Justice Morden spoke for the court. This particular case really gets me one up on Eddie Greenspan, because he had pointed in his speech to the oppressiveness of the present state of the law about extraordinary remedies, as exemplified in the High Court decision from which this very appeal was taken. In that decision, Mr. Justice Corey, then in the trial division, had decided that he could not grant certiorari to quash the magistrate's decision to commit Stilo for trial on the charge of indecent assault. The complainant was a girl of 7 years of age at the time of the alleged assault, and whose evidence, which was received unsworn, was the sole evidence against the accused. Yet Mr. Justice Corey felt he was bound by the authorities to refuse certiorari. Now, the Supreme Court of Canada earlier, and through Mr. Justice Pigeon, had stated in the Attorney General for Quebec versus Cohen back in 1979, quote, "In my view, there are cogent reasons for not departing from the rule that against a magistrate holding a preliminary inquiry, certiorari lies only for lack of jurisdiction, and a decision concerning the admissibility of evidence, even if erroneous, does not affect the jurisdiction." So that was the background to Mr. Justice Corey's dilemma. The child's evidence was unsworn, it was without corroboration, as required by the Evidence Act, and therefore the magistrate could not, or ought not to have committed the accused for trial. However, Mr. Justice Corey decided that he was bound not to grant certiorari, since the question of sufficiency of evidence was not a problem of jurisdiction. The Court of Appeal, speaking through Mr. Justice Morden, has just now stated otherwise. The Stilo decision establishes two propositions. Firstly, that a magistrate commits a jurisdictional error when he commits a person despite a complete absence of evidence. And secondly, that when there is a mandatory corroboration requirement, there is effectively no evidence before the magistrate on the preliminary inquiry until he has the required corroboration. I don't know whether that case is being appealed. It certainly seems to me to indicate that the courts are as sensitive now as ever to the real oppression which can befall an accused, and to use extraordinary remedies to correct the situation. To have to stand trial where there is really no evidence upon which a jury could find a guilty verdict is probably indeed oppressive. The Ontario Court of Appeal, at least, has maintained its power to correct such a situation. My two cases so far have been clear cases where extraordinary remedies have been applied for the benefit of an accused person. My third case is not that clear-cut, because the part of the case which I want to concentrate upon is undoubtedly obiter, and that limits its importance. The case is the Queen versus Riley, the reasons for which, in which were released by the Ontario Court of Appeal on June 19th of this year. And the part of the case upon which I want to concentrate deals with what's called abuse of process. During the last 5 years, the law surrounding the subject of abuse of process has been highly unsettled. And so, for my purposes, I want to follow quickly through that 5-year history, because it seems to me to be a good example of a progression in which one case builds upon another until suddenly a court can treat a legal notion which has been perfectly unchallengeable in the not-so-distant past. The starting point 5 years ago is, of course, the often referred to case of the Queen versus Rourke, where Mr. Justice Pigeon, speaking for the majority of the Supreme Court of Canada, said, quote, "For the reasons given in the Queen versus Osborne, I cannot admit of any general discretionary power in courts of criminal jurisdiction to stay proceedings, which were regularly instituted, because the prosecution, on the ground that the prosecution is considered oppressive. In fact, I think the correct view is that which was expressed as follows by Viscount Dilhorn in Director of Public Prosecutions versus Humphreys." He quotes, "A judge must keep out of the arena. He should not have, or appear to have, any responsibility for the institution of a prosecution. The functions of prosecutors and of judges must not be blurred. If a judge has power to decline to hear a case because he does not think it should be brought, then it soon may be thought that the cases he allows to proceed are cases brought with his consent or approval." End of quote. Some of the cases decided immediately after Rourke seem to take the view that it was no longer open to a Canadian court to prevent an abusive process by ordering a stay of proceedings. Chief Justice Laskin then cast some doubt on that response to the Rourke case in the case of Kersner in 1978, a case where an alleged drug trafficker claimed that he had been entrapped by the police. Chief Justice Laskin said, quote, "There is, of course, a balance to be struck between giving reasonable latitude to the police in the employment of stratagems to control the spread of crime, especially in the case of illegal drug traffic, and controlling behavior that goes beyond any reasonable latitude. American jurisdictions have, on a constitutional basis, sought to control the introduction of illegally obtained evidence. In England, the courts have continued to exercise a discretionary power to control the admissibility of evidence that would operate unfairly against an accused. Control techniques may thus relate to the recognition of substantive defenses, or to rules against the admission of evidence, or to a discretion as to its reception. Abuse of process," said the Chief Justice, "abuse of process or stay of proceedings have also been put forward as techniques of control." And later on, the Chief Justice said, "I leave open the question of whether the appropriate way to deal with entrapment is by way of a stay of proceedings, a matter considered by this court in another context in the Queen versus Rourke." That seemed to open the door a little bit and perhaps invite future lawyers to bring an appropriate case when the point might be more fully argued. The next case in the Supreme Court of Canada, which added to the progress in this matter, was Cranenburg, the case of Cranenburg in 1980. In that case, an accused appeared at court, ready for trial, on the day she had been ordered to appear, only to find that nothing happened. Apparently, through some error, her case was called in a different courtroom on that day, and when she didn't appear in that courtroom, the provincial judge issued a warrant for her arrest. She subsequently brought an application to quash that warrant and to prohibit the provincial court from further dealing with the information, and her application was successful. The Crown appealed all the way up to the Supreme Court of Canada. The appeal was dismissed on the basis that when the court did nothing against an accused, despite her having appeared at the appropriate time and place, there was a loss of jurisdiction over the offense, and the information and the warrants became invalid and of no effect. That seemed to dispose of the matter in that case, but Mr. Justice Dixon commented upon an observation that had been made in the appellate division in the Alberta Supreme Court. The observation was that, quote, a new information was available if one could be laid within the limitation period for summary conviction cases. And Mr. Justice Dixon commented, quote, the question of whether a new information may be laid after jurisdiction has been lost is not before us, and I refrain from any extended discussion on that point in the absence of argument and on the narrow facts of this case. It is manifest, however, that there will be occasions on which the laying of a new information will not be available. Time limitations may preclude it. He concludes, indeed, the laying of another information may amount to nothing less than an abuse of process. End of quote. Just as Chief Justice Laskin had in the earlier case that I quoted, Mr. Justice Dixon in this case was speaking in guarded tones. However, it seems to me to be fair to say that he was a little bit less guarded. His statement that an action may amount to an abuse of process is a more positive indication than Chief Justice Laskin's words, I leave open the question. So the second step had been taken. The third one, was crucial, was the crucial step of actually putting the doctrine into operation. And that can best be seen in the effect of two cases taken together in combination. In the Abitibi Paper Company Limited versus the Queen in 1979, Abitibi had come to an agreement with an official at the Ministry of the Environment about a program for cleaning up the company's pollution of a local river. The company set out to work on the agreed program, but a charge under the Environmental Protection Act was nevertheless laid, since the appropriate approval had not yet been granted by the director under the Act, and whose approval would have rendered the company immune from prosecution while the work proceeded. The Ontario Court of Appeal decided that a provincial offense was in the nature of a civil proceeding and that a stay of proceedings was available in a civil court. That was enough to dispose of the matter in that case, but Mr. Justice Jessup went on to an examination of the doctrine in the Rourke case to which I have referred, and Mr. Justice Jessup said, quote, I conclude, therefore, although not without hesitation, that abuse of process has a place in the criminal jurisdiction of our courts, but that its application is limited to cases of the most exceptional circumstances. Mr. Justice Arnott and Madam Justice Wilson refrained from commenting on the place of abuse of process in that particular case. But Mr. Justice Jessup's comments were taken up in the later case of the Queen versus Cernak, Bradley, and Shelley last year in Windsor, where Mr. Justice Creever stated, quote, I have come to the conclusion that Mr. Justice Jessup's comments, even though they may fairly be characterized as obiter dicta, are an accurate statement of the law, and that a superior court of criminal jurisdiction, which this court is, has power to stay proceedings against an accused for abuse of process, but only in cases of the most exceptional circumstances. End quote. That particular case, Mr. Justice Creever's decision, is an important one. It shows a court using its powers to stop oppression of an accused. However, I hasten to point out that the really decisive element in that case was the fact that an accused's defense was seriously prejudiced. That situation can be contrasted with much of the discussion on the subject of abuse of process, which is not concerned so much with individualized prejudice to an accused person, but with the more abstract question of the proper administration of the entire system of justice. It's really a question of emphasis. Instead of focusing on the position of the accused, much of the force in the doctrine is its focus on the police and upon the Crown. It is the extension to that level, which I've called a more abstract one, which brings me to the case of Riley, the Queen versus Riley, the reasons for which were released in June of 1981, where I think it can safely be said that there are no circumstances that are patently oppressive. The issue in that case I'm going to look at is almost disembodied from the actual facts of the case. Mr. Riley was arrested in 1980 on charges of impaired driving and of driving with more than 80 milligrams of alcohol per 100 milliliters in his blood. He was released on a promise to appear, which had been filled out for a return date of the 13th of January, 1980, when, of course, it should have said January 1981. And information was laid, and on January 13th, 1981, the inevitable happened. Riley didn't show up, presumably on the basis that there was no reason for him to do so in that year. The police then laid a second information, and a warrant was issued for his arrest. Riley promptly brought a motion to have the warrant quashed, was unsuccessful, and appealed to the Ontario Court of Appeal. He was unfortunately also unsuccessful there. The court decided that the warrant was properly based upon the second information and was therefore valid. That was enough to dispose of that case, but it's the extended reason proffered by the Court of Appeal after having made that disposition upon which I wish to focus for a few moments tonight. Mr. Justice Morden stated, I quote, "While this meets the only point raised by the appellant in challenge to the warrant in question in this matter, it is relevant and appropriate to consider whether there could be a direct objection to the institution of the second proceedings themselves. There is no express, or in my view, necessarily implicit provision in the Code prohibiting the institution of second proceedings while the first are still in existence, and it has been held that there is no such prohibition at common law. The Crown, of course, is restricted to proceeding on one information only. However, I think that where second proceedings are commenced, consideration has to be given to whether, having regard to the circumstances of the case, this amounts to an abuse of process," end quote. I want to draw particular attention to Justice Morden's phrase, "Consideration has to be given," he says, "to whether, having regard to the circumstances of the case, this amounts to an abuse of process." In the previous cases which I have considered in this paper, I have looked at, in the progression of the law, the judges had to go through a great deal of soul searching. The judges had to go through a great deal of soul searching as to whether or not a stay of proceedings even existed. We've seen that following upon Rourke. There was a guarded question by the Chief Justice, then a guarded comment by Mr. Justice Dixon, and then a very careful analysis by Mr. Justice Creever in a case where an accused would have been seriously prejudiced. By now, suddenly, we have the Court of Appeal, although it was on a point not raised by counsel, making a seemingly clear pronouncement that the doctrine of abuse of process has to be considered when two proceedings are commenced in reference to the same alleged offense. The doubts created by the Rourke case aren't even touched upon in the Court of Appeal. Abuse of process, it seems, has achieved a status where it can be referred to almost in an offhand manner as an accepted basis for extraordinary relief. However, the court decided that there was no abuse present on the facts of that particular case. I don't want to rely too heavily on this case, but if Riley does indeed indicate that the Court of Appeal's attitude, does correctly indicate the Court of Appeal's attitude towards abuse of process, I think we can anticipate a growing use of the remedy and a new development of the writs of certiorari and prohibition. Now, finally, I come to my fourth and last case, the case of the Queen versus Warren, the reasons for which were released on July 31st by Mr. Justice Linden. That case is concerned with that new area of administrative law known by the name of fairness. The classic recent statement in Canada, as all of you will have heard so many times by now, is in Nicholson and Peldam and Norfolk Regional Board of Commissioners of Police in 1979. That case has achieved great prominence. I don't intend to review it now. The court found that a Regional Board of Commissioners of Police had not fulfilled a duty to act fairly when it discharged a police constable without holding a hearing at which he could appear, and accordingly the court quashed the board's decision. The principles enumerated in Nicholson were then given intensive analysis in the case of Martineau versus Matsqui Institution Disciplinary Board in 1980. This case has also received widespread attention for the way that it carefully set forth the now evolving principles in this area of the law. Mr. Justice Dixon said, quote, "The dominant characteristic of recent developments in English administrative law has been expansion of judicial review, jurisdiction to supervise administrative action by public authorities. Certiorari evolved as a flexible remedy, affording access to judicial supervision in new and changing situations. In 1689, Chief Justice Holt could say, whenever any new jurisdiction is erected, be it by private or public act of Parliament, they are subject to the inspections of this court by writ of error or by certiorari and mandamus. The principles of natural justice and fairness have matured in recent years, and the writ of certiorari in like measure has developed apace." With those two cases in mind, I turn briefly to the Warren case. Warren was allegedly the operator of a strip club on Yonge Street, and in December 1980, he learned that the Crown was going to charge him with the offense of counseling a person to be nude in a public place in violation of Section 170 of the Code. In order for a charge to be laid, by reason of subsection 3 of Section 170, the consent of the Attorney General is required to enable the commencement of the prosecution. And so Warren's counsel wrote to the Attorney General asking for a hearing before such consent was given. Several letters were exchanged, but eventually consent was given without the requested hearing having been held. Warren's counsel then brought an application for certiorari to quash that consent, alleging that the Attorney General was under a duty to grant him a hearing after he had asked for it. Put another way, the issue in the case was whether the Nicholson principles applied to the conduct of the Attorney General in granting consent to a prosecution. Crown Counsel argued that the Attorney General's consent to such a prosecution was no different than the Attorney General's consent to such ordinary matters as preferring an indictment, which the cases clearly say he can do without review by a court. Mr. Justice Linden accepted that comparison and decided that the Nicholson principles did not cover in this situation. His reasons are contained in this passage, which I propose to read briefly. Quote, "It seems to me that Parliament has recognized that the office of the Attorney General is a significant one in the administration of justice, involving many decisions, including when to prosecute citizens and when not to do so. Historically, these decisions have not been subject to the review of the courts. His role in the legal process is to be kept distinct from that of the courts, and his freedom to make such decisions as he sees fit must remain free of review by the courts, unless, of course, the legislation dictates otherwise. For me, it makes no difference whether the power that he exercises is a power that he has exercised down through the ages, or whether it's a fresh power granted to him by Parliament. Once the power is given to the Attorney General, he may exercise it as he has historically exercised all of his powers, unless, of course, there is some specific fetter on that exercise which Parliament could easily have placed upon it." End quote. Two reasons seem to emerge from that passage. First, the historical position of the minister governs his present legal situation, unless a statute specifically provides otherwise. And second, the Attorney General's decisions must remain free of review by the courts. I'm sure that there are a number of government ministers who wish they were treated so respectfully when the courts come to look at their present powers and to make decisions. The second reason is not fully canvassed, but I think it is analogous to one that was advanced against recognition of the remedy of stay of proceedings. That is, the role of the judge and the role of the Crown must be kept separate. or else it will seem that only cases of which a judge approves are brought before the court. However, please note that the review Warren wanted was not a review of the actual decision which was reached by the Attorney General, but only the procedural way in which he reached it. For now, for immediate purposes, I leave open the question of whether a court's deference to the Attorney General's procedures is crucial to maintain the distinction between the Attorney General and the courts. It may be that there was also a third reason in the decision, one which comes not so much from that passage, but from various quotations which have been set out in the judgment. Term it a background reason. The idea that when the Attorney General exercises his discretion, he's doing so as a minister, in a ministerial act, thinking about the public good and the general administration of justice, and he is not functioning as a judge or even quasi-judicially. On the spectrum which was described by Mr. Justice Dixon in the Martineau case, it's a purely ministerial decision on broad grounds of public policy which will typically afford the individual no procedural protection, and any attack upon such a decision will have to be founded upon abuse of discretion. I want to finish my paper now by dwelling upon this background aspect of the Warren case, and then I will quickly conclude. The extraordinary aspect of extraordinary remedies is their power to enable judges to act, in the words of, I quoted earlier from the Keenan case, as judicial ombudsman. Any applicant is entitled to seek an extraordinary remedy in order to, quote, seek protection from the king and his courts when confronted with an excess of local powers. I intentionally emphasize the words "from the king" because they make it clear that the remedies do not stop with supervision merely of courts or judicial officers, but extend to all the king's officers, including his ministers. Nicholson and Martineau make it clear that it is not by virtue of his office that an administrative official can seek immunity from an extraordinary remedy, but only by virtue of the type of decision which he is making. Martineau tells us that a decision is immune from attack by extraordinary remedies only when it is a purely ministerial one. In that light, I want to look at the recent Supreme Court of Canada case, the Corporation of the Township of Innisfil versus the Corporation of the Township of Vespra, which was released on May 28th of this year. In that case, the Ontario Municipal Board heard an application by the Corporation of the City of Barrie to annex parts of the Corporation of the Township of Innisfil. And during the course of the application, received a letter from the Minister of Treasury, Economics and Intergovernmental Affairs stating that it was government policy that the Barrie urban area should have sufficient land annexed to it to accommodate a population of 125,000 by the year 2011. And that was despite the board's own acceptance of evidence which showed that the population of Barrie by the year 2011 would be unlikely to exceed 75,000. The board held that it was bound by the minister's figure and refused to allow counsel for the Township of Innisfil to cross-examine upon that letter. The Ontario Court of Appeal had found that the board did not make any error of law by that refusal. Mr. Justice Lecursier had stated, quote, the board's ultimate decision has an administrative, almost a legislative component, wherein the board has to weigh the merits of the application after considering all the relevant facts proven in the light of the objections presented and bearing in mind not only the local area but the general public interest, that of the population of the entire province. That aspect of the decision is administrative in nature and is guided by the board's broad view of the policy which it must implement. Later on, Mr. Justice Lecursier has stated, quote, specific government policy, such as the Barrie area population, constitutes a political policy decision for which the government is answerable to the electorate. In my view, provided such policy is not inconsistent with statutory objectives in the broad area of planning, an administrative board may conclude that it must be accepted having regard to all relevant facts and after listening to the objections raised, and cannot properly fall within the scope of judicial review scrutiny. The Supreme Court of Canada overturned the Court of Appeal's decision and held that the board erred in refusing to allow the cross-examination. Mr. Justice Esty, speaking for the court, rested his decision primarily on the grounds that the governing statutes, especially Section 14 of the Municipal Act, gave a person an absolute and unqualified right to object to an application being brought before the Ontario Municipal Board, including the right of cross-examination. He then went on to consider the secondary ground that the right existed at common law, and he said, "This is not a case of the right to cross-examination being used to challenge the policies of the executive branch of government in such a way as to bring the administrative tribunal into the political arena. It is merely the exercise by a party properly before the board on an annexation application of a right accorded to that party by the legislature." To my mind, one of the most striking aspects of this case is, if I read it correctly, that Mr. Justice Esty does not take issue with the way Mr. Justice Lecursier had characterized the board's type of decision. To repeat, Mr. Justice Lecursier had said that the board's ultimate decision was had an administrative, almost a legislative component. Mr. Justice Esty essentially went on to say only that, since the statute provided for a mandatory hearing, a fair hearing had to be held. Going back to the spectrum of decisions, which ranged from ministerial to judicial, apparently the board in this case had powers that were accepted as being at the ministerial end, and nevertheless, all the appropriate rules of fairness were held to apply. It may be that this case has added a significant extension to the duty to act fairly and has widened the range of the decision-making spectrum which can now be scrutinized by way of certiorari. And so, in conclusion, I return to the Queen versus Warren and the Attorney General. I'm sure that many of you people here this evening have had clients who at one time or another wanted to dispute an exercise by the Attorney General of his discretion. The time has not yet come, as the Warren case makes clear, when courts will review the procedures through which that discretion is exercised. I am certainly not willing to prophesy that a time will come when the courts will be willing to exercise their extraordinary remedies to make such a review. But I do point out, however, that there is an enormous vitality still to be discovered in extraordinary remedies and in their use to uphold the duty to act fairly by decision makers. And this vitality could operate in the sphere of criminal law just as well as in the more usual sphere of administrative law. That's the last of the four cases that I wanted to review. They have covered challenges to conditions on bail, challenges to committal for trial, difficulties with the laying of two informations over the same alleged offense, and challenges to the Attorney General's exercise of discretion. While the applications for relief were not successful in all of the four cases, the developments shown in the reports of those decisions lead me to think that the extraordinary remedy is just as alive and just as well as it ever was. Appeals are important, but they are still far from being the sole remedy that our criminal justice system has to offer. Indeed, if I may, just in closing, refer back to the lecture given earlier this evening by His Honor Judge DeDieper. He said, what I thought was a remarkable observation, that most license suspensions, which result from an accumulation of demerit points, are invalid and might well be remedied by certiorari or the like. When those words of his receive the widespread circulation that I know they will, by way of publication of the material from tonight, I fully expect that our court will be swamped with applications for certiorari. Thank you.
I must say I find it very interesting. It would seem to me, if I understood Mr. Justice Maloney correctly, that at least part of the theme of his discussion tonight was the fact that despite Eddie Greenspan's thesis in his Law Society lecture, extraordinary remedies are still alive and well. Eddie's been going around saying because of his speech the courts have finally seen the light and are starting to straighten out this area. Again, I want to thank all our speakers for their very worthwhile and comprehensive and excellent discussions tonight. And I thank all of you who made this possible for attending and showing that degree of regularity in attendance that certainly is appreciated by the speakers and by Brian and myself. And we hope to see you all next year. Thank you very much.